Before we begin, a quick and important disclaimer. The content presented in this video is intended solely for educational and entertainment purposes. It does not constitute professional legal, financial, or insurance advice. The mechanisms surrounding marriage law, divorce proceedings, and financial risk mitigation strategies are complex and highly dependent on individual circumstances and state-specific regulations. You should always consult with qualified professionals, such as attorneys or certified financial planners, before making decisions regarding your personal assets or contractual obligations. Please conduct your own due diligence and verify all information in the context of your own legal jurisdiction. Imagine standing on the precipice of a partnership that is not only a union of hearts but, statistically speaking, the single most significant financial merger of your entire life. Now consider that this merger carries a 50% failure rate, yet almost no one approaches it with the same rigorous due diligence they would apply to a small business acquisition. We spend months planning the party, the dress, and the catering, but we remain profoundly illiterate regarding the structural risks of the legal institution we are entering. What if I told you that in the United States, the most dangerous gamble you will ever take is not in the stock market or a speculative real estate venture, but in the courtroom during a dissolution of marriage? Today we are opening the vault on a concept that most Americans have never even heard of: the concept of marital risk and the specialized, often controversial mechanism of divorce insurance. If you think your prenuptial agreement is an impenetrable shield, you are likely operating under a dangerous illusion that could cost you your net worth. The problem this series solves is one of profound financial vulnerability. For decades, the American public has been sold the romantic narrative of marriage as an emotional endgame, intentionally obscuring the reality that it is a rigid legal contract with enforceable financial liabilities. When a marriage dissolves, the division of assets, the obligation of alimony, and the potential for long-term wealth erosion are governed by complex state laws that often favor the party with less earning power, regardless of the cause of the split. Most Americans are currently walking into this contract with zero hedge against the total collapse of the venture. By the end of this 10-part masterclass, you will understand the historical evolution of marital risk, the legal frameworks that define asset division, and the theoretical and practical role of financial instruments designed to mitigate the fallout of a domestic separation. To understand why this is a critical issue in the modern United States, we must first deconstruct the term marital risk. In a professional context, risk is defined as the potential for an outcome to differ from the expected result, usually resulting in a loss. In marriage, the expected result is a lifelong partnership. When that result is not achieved, the financial consequences are immediate and often catastrophic. Historically, the burden of this risk was managed through social and religious constraints. For centuries, the stigma of divorce acted as a barrier to entry for the legal process, and economic dependence ensured that staying married was often the only viable financial option for a significant portion of the population. However, the legal landscape shifted dramatically in the late 1960s and 1970s with the widespread adoption of no-fault divorce laws. California led this charge in 1969, fundamentally altering the contractual nature of marriage. Prior to this, you needed grounds for divorce such as adultery, cruelty, or abandonment. The introduction of no-fault divorce removed the necessity of proving wrongdoing, making it significantly easier and faster to dissolve a marriage. While this was a massive advancement for individual autonomy and the ability to exit toxic or abusive situations, it also introduced a new, permanent state of volatility into the institution of marriage. Every marriage in the United States effectively became a short-term contract that could be terminated by one party, at any time for any reason. This transition created a massive, unpriced liability. Think about it. If any other legal contract carried a 50% chance of being unilaterally terminated by your partner, with the court then forcing a mandatory 50-50 split of all assets acquired during the term, and potentially ongoing financial support payments, you would consider it a high-risk liability. You would likely be looking for insurance or a robust contingency plan. Yet, in the context of marriage, this risk is socialized and ignored. We avoid discussing it because it feels antithetical to the emotional commitment of the union. But the reality is that the law does not care about your emotional commitment. The family court system, while attempting to be equitable, is a mechanism for dividing assets, and it operates with cold mathematical precision. The concept of divorce insurance, or more accurately, the idea of financial protection against the costs of a failed marriage, has surfaced periodically in the American consciousness, usually met with significant public backlash. There have been ventures that attempted to market policies designed to pay out a sum of money upon the legal finalization of a divorce. These models generally failed or were forced to pivot because they were viewed as gambling on the destruction of a family unit, or they faced insurmountable regulatory hurdles. In the insurance industry, for a risk to be insurable, it must meet several criteria. It must be accidental, it must be unintentional, and it must not be subject to moral hazard. Moral hazard is the danger that the existence of the insurance will incentivize the very event you are trying to insure against. In marriage, it is incredibly difficult to determine if a divorce is truly an accidental event, or if the incentive structure created by a potential payout could influence the decision-making process. Yet, as we will explore in the upcoming segments of this masterclass, the desire to hedge against this risk is not going away. As wealth inequality in the United States widens and the average age of first marriage continues to climb, individuals are entering marriage with more significant assets than their predecessors. They are bringing student loan debt, retirement accounts, businesses, and real estate into the union. They are not just bringing themselves, they are bringing a portfolio of financial responsibilities. The stakes have never been higher, and the lack of systemic protection for those assets creates a persistent, underlying anxiety for a large segment of the American population. We are going to dissect how different states handle equitable distribution versus community property, how forensic accounting is used to uncover hidden assets during a divorce, and why the traditional prenuptial agreement is often challenged and overturned in court. We will move past the taboo and into the mechanics of the legal and financial reality. You need to understand the history of these laws to understand why you are currently exposed to certain risks. We are not here to fearmonger. We are here to analyze the structure of the American marital contract as if it were a high-stakes business merger, because from a legal perspective, that is exactly what it is. This is the first step in moving from a state of blind optimism to a state of informed preparation. Welcome to the deep dive. To understand the magnitude of the shift in American marital risk, we must look at the transition from fault-based systems to no-fault regimes. Imagine a young couple in 1950. Let us call them Sarah and Robert. They live in a world where the legal mechanism of divorce is a social nuclear option. To secure a divorce, one party had to provide evidence of a specific legal fault. This usually meant proving adultery, extreme physical cruelty, or abandonment. The financial consequences were inextricably linked to this proof of fault. The party who caused the marriage to fail was often penalized during the division of assets. There was an element of moral adjudication in the courtroom. The judge acted as a moral arbiter who decided who had broken the contract. This created a layer of legal protection for the innocent party. If you were the party who stayed committed, you had a stronger argument to retain your assets or secure support, because the court recognized your adherence to the social contract. Fast forward to 2026. The landscape has been transformed by the legacy of the late 1960s and early 1970s, when the legal definition of marriage shifted from a permanent bond to a contract that could be exited without cause. When California passed the Family Law Act of 1969, it set a precedent that swept across the country. Within a few decades, every state had adopted some form of no-fault divorce. This change was monumental because it removed the burden of proof. It meant that a marriage could be dissolved based on irreconcilable differences. While this significantly reduced the litigation costs associated with proving fault, it simultaneously stripped away the legal defensive wall that protected the individual who wanted to maintain the marriage. The financial risk profile for every person entering a marriage changed overnight. The potential for a sudden, unilateral exit by a partner became a standard feature of the institution. Consider the case study of a modern entrepreneur. Let us call him Michael. In 2026, Michael starts a business while married. He does not have a comprehensive prenuptial agreement because he trusts his partner implicitly. 5 years later, the business is thriving, and the couple decides to separate. Under the laws of a community property state, the assets Michael acquired during the marriage are generally considered marital property, regardless of whose name is on the title. Even if Michael did all the work, took all the risks, and put in 80 hours a week, the court sees the business as an asset generated during the economic partnership. Michael is now at risk of losing 50% of the value of that business, or being forced to buy out his former spouse, which could result in a total liquidation of the company's operating capital. This is not a failure of character. It is a failure of architectural planning. The legal system is performing exactly as designed, but Michael's financial plan never accounted for the legal reality of the no-fault transition. This is where the abstract concept of marital risk becomes a tangible financial threat. The American legal system essentially creates a default insurance policy that is mandatory for every married couple, but it is a policy that you cannot opt out of without extraordinary legal measures. This default policy is state-mandated. It dictates that your future earnings, your accumulated savings, and your equity in homes or businesses are subject to potential division upon the end of the union. When you do not proactively structure your financial affairs, the state provides the structure for you. And the state's structure is optimized for administrative ease and broad equity, not for the protection of specific, hard-earned individual wealth. You might ask why this risk is not managed by private sector insurance products. Historically, the insurance market has struggled to price marital risk. In the mid-2000s, there were entities that attempted to launch products marketed as divorce insurance. The business model was relatively simple. A consumer would pay premiums into a pool, and if they went through a divorce after a certain waiting period, they would receive a payout to help offset the costs of legal fees, living expenses, or asset division. However, these initiatives hit a wall of regulatory and ethical skepticism. Critics argued that offering financial compensation for divorce created a moral hazard. If an individual knows they will receive a significant payout upon divorce, they might be more likely to initiate the process during a minor rough patch rather than working through the marital conflict. This creates a feedback loop that undermines the stability of the institution the policyholder is supposed to be protecting. Furthermore, there is the issue of adverse selection. The individuals most likely to purchase divorce insurance are those who already perceive a high risk of their marriage failing. This is similar to someone trying to buy fire insurance only after they smell smoke in their kitchen. Insurance works on the principle of pooling a large, diverse group of risks. If the pool is composed only of people who are already on the verge of divorce, the premiums would have to be astronomically high to cover the eventual payouts, making the product unappealing to the average consumer. This structural hurdle has prevented the emergence of a mainstream, robust market for divorce insurance in the United States. However, we are currently seeing a shift in how high-net-worth individuals and younger generations view these risks. We are seeing a move away from the hope-based financial model and toward a contractual, data-driven approach. People are increasingly using trust structures, complex business entities, and sophisticated asset separation strategies to achieve the same result that a traditional insurance policy might offer. They are insulating their assets not through an insurance company, but through the legal architecture of their financial lives. This is the modern version of managing marital risk. When we analyze the history of divorce and the evolution of the American family, we see that the legal system is constantly playing catch-up with shifting social and economic realities. We moved from a period where divorce was a scandal to a period where it is a standard administrative procedure. We have moved from a time where assets were largely held in the name of the male provider to a time of dual-earning households with complex, commingled financial portfolios. Yet, our collective understanding of the risks associated with this complexity remains dangerously stuck in the past. We act as if the marriage contract is a static event, when it is actually a dynamic, multi-decade financial transaction with the highest stakes imaginable. In the next part, we will begin to dismantle the myths surrounding the prenuptial agreement. Most people assume that a prenuptial agreement is a golden ticket, a way to freeze assets and exempt oneself from the legal defaults of state law. But the courtroom tells a very different story. We will examine why your prenuptial agreement might be shredded to pieces the moment it faces a judge, and what specific technical flaws in document drafting leave millions of Americans exposed to total wealth transfer every single year. You think you are protected, but the reality is much more precarious. The upcoming breakdown of contract enforcement will change how you view your own financial planning forever. The prenuptial agreement is perhaps the most misunderstood instrument in the history of American family law. It is treated by the general public as a magical barrier that separates two lives into independent silos. Yet in the cold, unyielding reality of a 2026 family court, it is often treated as nothing more than an advisory document. To understand why, we must move beyond the common narrative that a prenup simply creates a clear division of assets and examine the rigorous legal scrutiny these contracts face. Imagine a high-net-worth individual, let us call him David, who possesses significant premarital assets and a burgeoning tech startup. In 2024, before marrying his partner, Susan, David insists on a prenuptial agreement. He hires a reputable attorney, they draft a meticulous document, and they have it signed and notarized well in advance of the wedding date. They feel secure. Fast forward 2 years to 2026. David and Susan reach a point of irreconcilable differences and file for divorce. David presents the prenup to the court, expecting it to function as a shield for his premarital wealth and his business equity. Instead, Susan's legal team files a motion to invalidate the agreement. They argue that David coerced Susan, that there was insufficient disclosure of assets at the time of signing, or that the agreement has become unconscionable due to changing circumstances. This is where the illusion of protection shatters. Courts in the United States operate under a mandate of equity. While freedom of contract is a pillar of American law, it is curtailed in the realm of family law by the state's interest in preventing poverty and ensuring that former spouses are not left destitute. If a court decides that the enforcement of a prenuptial agreement would result in an unfair financial outcome, particularly if one party has become dependent or if the standard of living of the lower-earning party would drop precipitously, the judge has broad discretionary power to set aside specific provisions or the entire contract. Consider the requirement of full and fair disclosure. This is a technical trap that catches countless people off guard. If David failed to disclose the true valuation of his startup, his offshore holdings, or his future earning potential in the schedules attached to the prenup, the entire contract can be voided for fraud or non-disclosure. It is not enough to list assets, they must be accurately valued. In 2026, with the rise of complex digital assets, cryptocurrency holdings, and intellectual property, the definition of full disclosure is becoming increasingly difficult to satisfy. If the court finds that there was even a minor omission, it can trigger a total unraveling of the protection. Furthermore, there is the concept of procedural versus substantive unconscionability. Procedural unconscionability examines the fairness of the negotiation process. Did the other party have their own independent legal counsel? Was the agreement presented in a high-pressure environment, like a week before the wedding? If Susan was forced to sign the document without the benefit of her own attorney, or if she was presented with it under circumstances that made her feel that the wedding would be called off if she did not sign, a court might determine that the document was signed under duress. This is a common historical trend in litigation. The emotional pressure of the wedding preparations is, in the eyes of a judge, a form of coercion that undermines the voluntary nature of the contract. Substantive unconscionability, on the other hand, looks at the result of the agreement. If the agreement is so lopsided that it leaves one party with nothing after a decade of marriage, a judge is likely to find it offensive to public policy. The court does not want to create a situation where one party becomes a public charge, relying on social safety nets because a contract stripped them of all resources. This is why many experienced family law practitioners advise that a prenuptial agreement must be reasonable and provide a fair settlement for both parties to have any long-term viability in court. Beyond the document itself, we have to look at the commingling of assets. Even if you have an ironclad prenuptial agreement, your behavior during the marriage can effectively nullify its protections. Let us revisit David and Susan. Even if the agreement specifies that David's premarital business is his sole property, what happens if David uses joint marital funds to pay for the startup's operating expenses, or if Susan contributes her time and effort to the management of the business? This creates a concept known as the transmutation of property. The separate property becomes commingled with marital property. The court now has to perform a forensic audit to trace the origin of every dollar, every share of stock, and every piece of equipment. In many cases, the effort to separate these assets is so costly and complex that the litigation fees alone consume a significant portion of the value at stake. This is why we cannot view the prenuptial agreement as a set-it-and-forget-it financial tool. It is a living, breathing contract that requires ongoing maintenance. It requires the parties to maintain strict financial boundaries throughout the duration of the marriage. It requires that you do not mix the funds, that you keep detailed records of all transactions, and that you periodically review the agreement to ensure it remains relevant to the current economic reality. Most people fail at this level of maintenance, which is why the breach rate in high-asset divorces remains so elevated. We are seeing a trend where individuals are moving toward even more complex, multi-layered strategies to protect their wealth. If a prenup is a weak shield, what is a strong one? Some are turning to irrevocable trusts, family-limited partnerships, and international asset protection structures. But these tools come with their own set of risks, including significant tax implications and a loss of control over the assets. The trade-off between absolute protection and practical utility is the central dilemma of modern financial planning in a high-risk marital environment. As we look at the data, it is clear that the financial impact of a divorce is not just about the loss of current assets, but about the long-term impact on retirement security and future wealth accumulation. A major divorce at age 45 can reset a person's financial life to zero, undoing decades of disciplined saving and investing. This is the hidden, often ignored, cost of the no-fault era. In the next part, we are going to pivot toward a forensic analysis of how the court actually values these assets. We will explore the hidden complexities of business valuation during divorce, the role of professional appraisers, and the specific strategies used by legal teams to inflate or deflate the value of assets during the discovery process. You might think you know what your business or your home is worth, but when a judge has to divide it, the number is often vastly different. We will examine the gap between your perception and the court's reality. Understanding this gap is essential for anyone who intends to protect their financial future in the modern United States. When a marriage moves into the dissolution phase, the abstract concept of marital risk crystallizes into a very concrete, often adversarial, process known as the valuation of marital assets. In 2026, most Americans believe that the value of their household is simply the current market price of their assets, minus their liabilities. However, in the eyes of a family court, that number is merely the starting point for a complex negotiation where the final output is often dictated by the strategic positioning of legal and financial experts. Consider a professional couple, let us call them Jessica and Mark, residing in a major metropolitan area. They have accumulated a diverse portfolio over 10 years of marriage, including a primary residence, 2 retirement accounts, various investment holdings, and Mark's interest in a private consulting firm. When they initiate a divorce, they are required to disclose their assets. This discovery process is where the first major battle occurs. One party might have an incentive to undervalue the consulting firm to minimize the payout, while the other might have an incentive to inflate it to maximize their claim. This is not just a matter of disagreement. It is a tactical exercise in forensic accounting. The role of the forensic accountant is paramount here. These professionals are tasked with tracing the history of every asset to determine if it is separate property or marital property. They analyze bank statements, tax returns, and investment records to uncover hidden assets, or to demonstrate how marital funds were used to support non-marital assets. For example, if Mark used a joint checking account to pay for the insurance premiums on a life insurance policy he owned before the marriage, a forensic accountant might argue that a portion of that policy's value has become marital property through the infusion of marital funds. This is a common historical trend in litigation that catches many off guard, because they view such payments as routine household management rather than a potential transfer of asset classification. The valuation of a private business or professional practice is perhaps the most contentious area of this process. The court typically requires a business valuation expert to determine the fair market value of the entity. But what defines fair market value? Is it the value if the business were sold to a third party? Or is it the value of the business to the owner, considering its current cash flow and future earning potential? These valuation methodologies often yield wildly different results. An expert hired by the party trying to protect the asset might use a conservative valuation method, focusing on the asset base, while an expert hired by the other party might use a more aggressive method, capitalizing projected future earnings. This leads to the gap between perception and reality. Jessica might perceive the consulting firm as a small, volatile venture with little intrinsic value. However, the court's valuation might be significantly higher, based on the historical revenue the firm has generated and the strength of its client contracts. If the court assigns a high valuation to the business, Mark may be forced to pay Jessica a large sum to equalize the division of assets. If he does not have the liquid capital to make that payment, he may be forced to sell the business, take out a high-interest loan, or agree to a less favorable settlement elsewhere, such as relinquishing his stake in the family home. This is why the discovery process is so critical. Discovery is the legal mechanism through which each side demands documentation from the other. It includes interrogatories, requests for production of documents, and depositions. In 2026, this process has become increasingly digital. We are talking about thousands of pages of emails, cloud-based accounting files, and encrypted communication logs. The complexity of this data means that the cost of discovery can easily run into the tens, if not hundreds of thousands of dollars. This is a point of attrition in the American legal system. The cost of identifying the true value of an asset can sometimes exceed the value of the asset itself, especially in middle-class divorces. We must also address the impact of state law. The division of property follows one of two primary frameworks: community property, or equitable distribution. In a community property state, the default assumption is that all assets acquired during the marriage are owned equally by both parties. This provides a clear, if rigid, starting point. In an equitable distribution state, the court has more discretion to divide property in a manner that it deems fair, which does not necessarily mean an equal 50-50 split. This adds a layer of uncertainty, as the final outcome depends on the individual judge's interpretation of fairness, which can include factors such as the length of the marriage, the contributions of each spouse, and the future earning capacity of each party. This variability is the reason why many high-net-worth individuals seek to move their assets into structured vehicles like family-limited partnerships or complex trust structures before or during the marriage. These structures are designed to provide a layer of legal distance between the individual and the asset. However, as we discussed in the previous section, if these structures are used to intentionally hide assets or to defraud a spouse, the court can pierce the veil of these entities. The law is not static. It is constantly evolving to catch up with the creative ways in which people attempt to insulate their wealth. When you think about the total landscape of marital risk, you have to realize that it is not just about the loss of assets, it is about the loss of control. When you walk into a courtroom, you are handing over the decision-making power regarding your financial future to a judge who is managing a docket of hundreds of other cases. You are moving from a state of private negotiation to a state of public adjudication. This is the ultimate, and perhaps the most dangerous outcome of a failed marital contract. You lose the ability to tailor a solution that works for your unique situation, and you are bound by a decision that is governed by broad legal principles. The next part of this masterclass will explore a topic that is often treated as the ultimate taboo in American divorce: spousal support, or alimony. We will look at how this mechanism is calculated, why it has shifted from a permanent obligation to a temporary bridge in many jurisdictions, and the specific factors that judges use to determine both the amount and the duration of payments. You think you know how it works, but the shift in how courts view economic self-sufficiency has fundamentally altered the reality of post-divorce financial life. We are going to look at the math behind the payments. Spousal support, often referred to as alimony, represents one of the most volatile variables in the American divorce equation. For many, it is viewed as a form of social security designed to protect a dependent spouse. For others, it is perceived as an archaic penalty that serves as an indefinite financial anchor. To truly understand its role in marital risk, we have to move beyond the emotional rhetoric and analyze the actual mathematical and legal frameworks that govern these payments in 2026. Historically, alimony was a permanent, lifelong obligation. It was rooted in a societal structure where one partner, typically the wife, exited the workforce to manage the home and raise children, effectively forfeiting her ability to build a career, earn an income, or accrue retirement benefits. In that context, alimony was the mechanism that prevented her from falling into poverty upon the dissolution of the marriage. It was the price the breadwinner paid for the disruption of the domestic partnership. However, as the American economy shifted toward dual-income households, the legal view of alimony underwent a radical transformation. Modern family courts have largely pivoted toward the goal of economic self-sufficiency. The objective of spousal support is no longer to maintain a perpetual standard of living for the recipient, but to bridge the gap while the dependent party gains the necessary skills or education to rejoin the workforce and sustain themselves. This is a critical distinction that dictates how alimony is calculated, and more importantly, how long it lasts. In many jurisdictions, we are seeing a shift away from permanent support toward rehabilitative or durational support. Imagine a case study of a couple, let us call them Robert and Sarah. They have been married for 15 years, during which Sarah worked part-time while raising their children, while Robert advanced his career in corporate finance. When they divorce in 2026, the court will look at several specific factors. These include the length of the marriage, the age and health of the parties, their respective earning capacities, and the contributions each made to the marriage, both financial and non-financial. The court will then calculate a support amount that attempts to balance Sarah's need against Robert's ability to pay. The math behind this calculation is not standardized. It is not like a tax bracket where there is a clear fixed rate. Instead, it is an exercise in judicial discretion. In some states, there are software tools and guidelines that provide a starting point for calculation, but a judge always retains the authority to deviate from these guidelines based on the unique circumstances of the case. This leads to massive variability. Two couples with identical income profiles can end up with entirely different support obligations depending on the judge, the county, and the effectiveness of their respective legal representation. One of the most complex aspects of this calculation is the determination of earning capacity. If Sarah has a degree but has not worked full-time in a decade, the court may assign her an imputed income. This is a hypothetical income that the court believes she could earn if she were working at her full potential. If the court decides that Sarah could reasonably earn $60,000 a year, but she chooses not to work, the court may calculate the alimony based on that $60,000 as if she were already receiving it. This is a powerful and often contentious tool used by judges to prevent one party from under-earning to inflate their support claim. This brings us back to the concept of marital risk. If you are the higher-earning spouse, you are carrying a significant contingent liability that can last for years, sometimes decades. This liability can affect your ability to qualify for a mortgage, your ability to save for your own retirement, and your ability to start new business ventures. It is a drag on your financial velocity. Conversely, if you are the lower-earning spouse, you are at risk of being awarded an insufficient amount that does not account for the true cost of transitioning back into the workforce in a competitive labor market. Many high-net-worth individuals are now negotiating buyout settlements. Instead of paying monthly alimony for 10 years, the parties might agree on a lump sum payment that settles the obligation once and for all. This is essentially a risk transfer mechanism. The paying party provides a larger, upfront cash settlement to be released from any future monthly obligation. This provides the recipient with immediate liquidity and removes the uncertainty of future payments, while it provides the payer with a clean break and the ability to move forward without a lingering financial tether. However, this is only possible if there is enough liquid capital to fund the buyout. We are also seeing the emergence of post-divorce financial planning as a specialized field. Professionals are now helping individuals restructure their portfolios specifically to survive the impact of these support obligations. This includes tax planning, as the tax treatment of alimony has changed significantly under recent federal law, shifting the burden in a way that impacts the net cash flow available to both parties. Understanding the intersection of tax law and family law is now a mandatory skill for anyone managing the aftermath of a high-stakes divorce. The legal system's attempt to achieve equity is inherently messy. It is an attempt to solve a highly subjective problem, the destruction of a family unit, with an objective tool, a payment schedule. This mismatch is why so many people feel that the process is inherently unfair, regardless of which side they are on. The goal of this analysis is not to argue for or against these laws, but to map the landscape so that you can anticipate the terrain. As we move toward the next segment, we will address the role of children in this financial architecture. The inclusion of child support introduces an entirely new set of federal and state guidelines, often superseding any agreements the parents might reach between themselves. We will look at how child support is calculated, why it is generally immune to contractual modification, and how it complicates the broader financial planning for divorced parents. You might think you can agree on what is fair for your children, but the state has its own formula, and it is mandatory. The intersection of child support and marital dissolution is where the legal system stops being a tool for asset division and starts being an instrument of state-mandated welfare. Unlike property division or even spousal support, where parties have some degree of room to negotiate and settle, child support is almost entirely non-negotiable. In 2026, every state in the United States utilizes strict guidelines to determine the financial obligation for the upbringing of children. These guidelines are not suggestions. They are rigid formulas that prioritize the maintenance of the child's standard of living over the parent's desire for autonomy. Consider the case of a professional couple, let us call them David and Elena, who are navigating a divorce in 2026. They have 2 school-aged children and have reached a mutual agreement that Elena will provide more financial support for the children's private schooling and extracurricular activities because she earns more. They draft a settlement agreement reflecting this choice. However, when they submit this to the court, the judge may reject it if it deviates significantly from the state's mandatory child support formula. The court's perspective is that the right to child support belongs to the child, not the parents, and therefore, parents cannot sign away or alter this right through private contract. The formula itself typically considers the combined gross income of both parents, the number of children, and the amount of time each parent spends with the children, often referred to as parenting time or custody percentages. The income calculation is not merely a base salary figure. It includes bonuses, commissions, investment income, and even the value of non-cash benefits like employer-provided vehicles or housing. This is a massive point of friction in high-net-worth divorces. If one parent owns a business and manages their W-2 income to appear lower, the court often imputes income based on the business's total cash flow, effectively treating the business as an extension of the parent's personal income. This creates a significant marital risk because the child support obligation is tied to the parent's income and can be modified upward if the parent's income increases. Imagine a scenario where David gets a promotion 2 years after the divorce. Elena can file a petition for a modification of child support, and the court will likely recalculate the obligation based on the new, higher income. This creates a perpetual dynamic liability that can span 18 or more years. It is a long-term financial burden that is entirely dependent on future income, which by definition makes it a risk that cannot be easily hedged. We must also distinguish between child support and what is often referred to as add-ons. These are the extraordinary expenses, such as private school tuition, unreimbursed medical expenses, and specialized therapy or tutoring. These are typically split between the parents based on their respective percentages of total income. A parent who feels they have settled their divorce cleanly is often caught off guard when they are served with bills for these extras years after the divorce is finalized. This is where the lack of foresight often manifests. Many couples fail to define what constitutes an extraordinary expense, leading to endless litigation over things as minor as summer camp fees or athletic equipment. There is also the phenomenon of the age of majority. In most states, the obligation to pay child support ends when the child turns 18 or graduates from high school. However, a growing number of states are exploring or have already implemented laws requiring parents to contribute to the cost of higher education. This can extend the child support burden well into the child's early 20s, potentially overlapping with the parent's own retirement planning window. This is a critical risk factor that is often overlooked in the initial divorce settlement. If you are 50 years old at the time of your divorce, your child support obligation could effectively run until you are 65, consuming capital that you should be putting into your retirement portfolio. From an insurance perspective, this risk is managed in only one way: life insurance. Most divorce decrees mandate that the payer of child support carry a significant life insurance policy with the children, or the other parent as trustee, as the beneficiary. This ensures that if the paying parent passes away, the child support obligation is funded by the death benefit. This is a rare, and often the only, instance where the court forces the use of a private insurance product to mitigate the risk of financial loss upon the death of a parent. It is a mandatory hedge that highlights the state's intense focus on ensuring that the financial burden of child support does not fall on the public sector. However, the risk remains for the living parent. If your business fails, if you lose your job, or if your income drops due to a career change, you are still bound by the original child support order until you can prove a significant change in circumstances to the court. Proving this change requires an extensive and often expensive legal process. The court does not automatically lower the payments because you lost your job. You must proactively petition the court, provide documented evidence of your financial hardship, and navigate a process that can take months. During that time, your legal obligation to pay continues to accrue, and failure to pay can lead to severe consequences, including the suspension of your professional licenses, the freezing of your bank accounts, and even jail time. This reality makes child support the most rigid and punitive aspect of the entire divorce process. It is the one area where the state's enforcement mechanism is most aggressive. Unlike a debt to a credit card company or a mortgage lender, where a default results in a loss of credit score or foreclosure, a default on a child support obligation is a violation of a court order. The legal system is designed to prioritize the collection of these payments above almost all other private financial obligations. As we look ahead, we must confront the reality of how this interacts with the concept of long-term wealth preservation. If you are constantly exposed to the variability of child support, and you are mandated to pay for educational expenses that are outside of your control, how can you build a solid financial foundation? The answer often lies in how you structure your assets before you even consider marriage. But for those already in the middle of this, the focus must shift to meticulous documentation and a proactive stance toward the court's modification procedures. In the next part, we will pivot to the role of debt. Many people focus on how to divide the assets, but they ignore the burden of marital debt. Credit card debt, personal loans, and tax liabilities incurred during the marriage are often treated differently than assets. We will analyze the concept of joint and several liability, which is a trap that ensnares many unsuspecting divorced individuals, leaving them responsible for debts they did not even know existed. You might have left the marriage with no assets, but you could still be on the hook for every cent of your former partner's spending. We will examine how to audit your debt exposure before it becomes a legal nightmare. The trap of joint and several liability is perhaps the most devastating financial realization for those undergoing a divorce in 2026. Many people operate under the mistaken belief that once a judge signs a decree of divorce, all joint financial obligations are cleanly severed. They assume that if the court orders their former spouse to pay off the mortgage or the credit card debt, that debt is no longer their problem. This is a profound misunderstanding of how the legal system interacts with private creditors. Imagine a couple, let us call them Sarah and Michael. During their marriage, they accumulated $50,000 in credit card debt. When they divorce, the court issues an order stating that Michael is responsible for paying off that balance. Sarah feels relieved and moves on with her life. However, 2 years later, Michael faces financial hardship and stops making the payments. The credit card company does not care what the divorce decree says. Because Sarah was a co-signer or an authorized user on those accounts, she remains jointly and severally liable for the debt. This means the creditor can pursue Sarah for the full amount, plus interest and late fees, and they can report the delinquency to credit bureaus under her name, effectively destroying her credit score. This is the reality of the creditor relationship. It is a contract between you and the bank. The court order is a contract between you and your former spouse. The bank is not a party to your divorce proceedings, and they are not bound by the judge's orders. Unless the creditor explicitly agrees to release you from the debt, a process called a novation, you remain on the hook. This is a common historical trend where individuals find themselves financially tethered to their ex-spouse years after the marriage has ended, not because they failed to plan, but because they failed to understand the nature of the contracts they signed during the union. When we talk about marital debt, we must look at how it is categorized. There is community debt, which is incurred for the benefit of the marriage, and there is separate debt, which is incurred for a personal or non-marital purpose. But in practice, the lines are incredibly blurry. If Michael took out a personal loan to start a side business, was that for the benefit of the marriage or for his own personal pursuit? If the couple used the proceeds of that loan to pay for family vacations or home renovations, the court will likely view it as a marital debt. This is why forensic accountants are often needed to trace the use of borrowed funds. Consider the risk of tax liability. If a couple has been filing joint tax returns for years, they are both legally responsible for the accuracy of those returns. If the IRS discovers an error or an instance of tax evasion related to income that one spouse hid from the other, both spouses are liable for the back taxes, penalties, and interest. This is known as joint and several tax liability. Even if you were not the one who earned the income or prepared the return, the IRS can come after you for the full amount. In 2026, with the increasing complexity of cross-border income and cryptocurrency transactions, this is a significant risk. Protecting yourself requires a thorough audit of all past tax filings, often using a tax professional who specializes in innocent spouse relief claims. The audit of debt exposure is a step-by-step process that should begin long before a divorce is even on the horizon. First, you must obtain a comprehensive report from all 3 major credit bureaus to identify every account that bears your name. You must also review all bank statements, loan applications, and property records to identify potential liabilities that may not show up on a standard credit report. Many people are shocked to find out that they are listed as a guarantor on a business loan, or that their spouse has opened accounts in their name without their explicit knowledge. Once you have identified these debts, the strategy is to move toward de-risking. This involves closing joint accounts, paying off high-interest debt that is shared, and working with lenders to refinance debts into a single name. If a lender refuses to release you from a joint debt, you must treat that liability as a primary risk factor in your divorce settlement. You must demand that your former spouse provide collateral, such as a lien on property or a cash escrow account, to secure their obligation to pay that debt. If you do not secure the debt, you are effectively providing your former spouse with a no-interest, high-risk loan. We must also consider the role of debt in the valuation of assets. When we calculate the net value of an estate, we subtract the total liabilities from the total assets. If a couple has high-value real estate but also carries significant debt against that property, the net value might be much lower than expected. A critical mistake is to focus on the gross value of assets while ignoring the debt that encumbers them. In 2026, with property values fluctuating and debt loads rising, an accurate net worth calculation is essential for a fair division. The accumulation of debt during a marriage is often an invisible process. It is a slow buildup of small expenses that eventually becomes a crushing financial burden. When the marriage ends, this burden is exposed. If you are not prepared for this exposure, you can find yourself in a situation where your share of the assets is completely wiped out by your share of the debts. This is the ultimate and most preventable failure in financial planning. In the next part, we will move away from the internal mechanisms of the divorce process and into the broader landscape of how technology and digital data are changing the game. We will look at how social media, cloud storage, and digital transaction histories are being used in court to influence the outcome of cases. Your digital footprint is no longer a private record. It is a vital piece of evidence that can be used to prove or disprove almost any claim made during a divorce. We will analyze the specific ways your online behavior is now a factor in the risk assessment of your marriage. The digital transformation of the American legal system has turned every smartphone, social media account, and cloud sync device into a silent witness to the dissolution of a marriage. In 2026, the concept of digital evidence in divorce proceedings has expanded far beyond simple text messages. We are talking about the systematic extraction of metadata, location history, and cloud-based activity logs that provide a granular, second-by-second narrative of a person's life. If you assume that your online behavior is private or irrelevant to the courtroom, you are operating under a misconception that has been the downfall of many litigants. Imagine a scenario where one spouse, let us call him James, claims he has no liquid assets and is struggling to pay his bills. He files for a reduction in alimony. However, his estranged spouse's legal team files a motion for discovery regarding his digital activity. They gain access to his social media posts, his app usage, and his digital transaction history. They find images of him at luxury resorts that he never disclosed, receipts for high-end purchases stored in his email cloud, and geolocation data showing he spent significant time at an undisclosed business location. This is not just a disagreement. It is the use of digital footprinting to impeach his credibility. In the eyes of a judge, if a party is caught in a lie about their financial status, their entire testimony becomes suspect. The power of digital evidence lies in its permanence. Everything you post, everything you delete, and everything you store in the cloud leaves a trace. Even when you believe you have deleted a message, it is often archived on a server, stored in a cloud backup, or saved in the metadata of an application. Forensic digital experts are now a standard fixture in high-stakes divorces. They do not just look at what you wrote, they analyze how you wrote it, when you wrote it, and where you were when you wrote it. They can reconstruct a timeline of communication that proves a pattern of behavior, which is often far more damaging than a single isolated incident. Take the role of location tracking. Most modern smartphones are constantly recording your geographic history. If you are involved in a dispute over child custody, the location history on your phone can prove whether you were actually with your children during your scheduled parenting time, or whether you were at a location that contradicts your claims. This data is admissible in court. It provides an objective, unvarnished record of your movements. The same applies to social media check-ins and the metadata embedded in photos, which can track exactly when and where an image was taken. This is why we characterize this as a new layer of marital risk. Your digital life is now a permanent record that can be subpoenaed and scrutinized. It is not just about the content of your posts. It is about the implicit evidence they contain. For example, if you post a photo of yourself in a new car that you claimed you could not afford, you have provided tangible evidence that contradicts your sworn financial statements. This is a common historical trend in litigation, where the vanity of social media exposure creates a self-inflicted wound in the courtroom. Beyond the content you create, we must also consider the hidden data in your home and personal devices. Smart home technology, including voice assistants, smart locks, and connected appliances, creates a log of activity within your home. These devices can record when a door was unlocked, when a light was turned on, or when a specific conversation occurred. While the legal standards for accessing this data are still evolving, it is increasingly being introduced as evidence to corroborate or refute claims about home life, schedules, and even domestic interactions. The risk extends to your interactions with third-party applications. Think about ride-sharing history, food delivery logs, and fitness tracking apps. These all provide a detailed, time-stamped record of your daily habits. If you are claiming that you were home all weekend, but your ride-sharing app shows you were at a bar in another city, you have created a permanent record of your dishonesty. The courts are becoming increasingly adept at using this data to force transparency, in a process that is often characterized by obfuscation. This brings us back to the necessity of digital hygiene. If you are in a high-risk marriage, or if you are considering the potential for a future divorce, you must be hyper-aware of your digital footprint. This does not mean you should attempt to destroy evidence, which is a criminal act known as spoliation of evidence and carries severe legal penalties. Instead, it means you must operate with the understanding that every digital interaction is a permanent record. You must manage your privacy settings, limit the information you share, and be mindful of the data trail you leave behind. Furthermore, the threat of cyber surveillance is a reality. We see cases where one spouse uses spyware or unauthorized access to monitor the other's digital activity. This is not only a violation of privacy laws, but it is also a tactical disaster in court. Evidence obtained through illegal surveillance is generally inadmissible, and the act of obtaining it can severely damage the credibility of the person who committed the intrusion. It is a desperate, short-sighted maneuver that often results in the court imposing sanctions or adverse rulings against the offender. The integration of digital data into the family court system is the final piece of the puzzle in understanding why the modern divorce process is so much more volatile than it was in the past. We have moved from a system of verbal testimony and paper records to a system of digital interrogation. Every aspect of your life is now subject to discovery, and the definition of a document has expanded to include everything from your search history to your smart home logs. In the next part, we will explore the very concept of the divorce settlement itself. We have discussed the risks, the assets, the debts, and the digital evidence. But how do you actually structure a deal that provides long-term security? We will examine the architecture of a settlement agreement. We will look at why some agreements succeed in standing the test of time, while others lead to a decade of post-divorce litigation. We will break down the components of a master-level settlement that addresses the potential for future changes in income, economic shifts, and the evolving needs of the family. You need to understand how to build a contract that is meant to survive the next 20 years, not just the next 20 minutes. The architecture of a master-level divorce settlement is an exercise in anticipating the future, a task that requires a radical departure from the emotional turbulence of the separation phase. In 2026, the most successful settlements are those that explicitly account for the reality that the financial, personal, and professional lives of both parties will evolve significantly over the next 2 decades. A settlement that focuses solely on the current state of affairs is a failed contract waiting to happen. To understand the design of a resilient settlement, we must analyze the specific components that transform a static agreement into a dynamic framework. The foundation of any master-level settlement is the inclusion of clear, non-ambiguous trigger events. A trigger event is a specific, defined occurrence that automatically mandates a review or modification of the agreement. For instance, instead of leaving spousal support open-ended, a high-level settlement will specify that payments will reduce by a set percentage upon the occurrence of events such as the recipient reaching a specific age, the recipient securing full-time employment at a defined income level, or the payer reaching the traditional retirement age. By defining these triggers, you remove the necessity for future litigation. You are replacing judicial discretion with contractual certainty. Imagine a case study involving a business owner, let us call him Marcus, and his spouse, Elena. Their settlement includes a clause stating that if Marcus's business revenue increases by more than 20% in a single year, a portion of that excess is automatically allocated to a long-term educational fund for their children, rather than being added to the base support payment. This is a sophisticated way of handling variable income that prevents the need for a return trip to court. It treats the family financial structure like a corporate holding company, where distributions are based on performance metrics rather than arbitrary demands. A second critical component is the integration of dispute resolution mechanisms that prioritize efficiency. Instead of defaulting to the court system for every disagreement, a master-level settlement mandates a tiered approach. First, the parties must utilize a neutral mediator. If mediation fails, they move to binding arbitration with a specialist who has deep knowledge of their specific financial structure. This keeps the conflict private, reduces the legal fees, and prevents the unpredictability of a judge who may not understand the complexities of their business or investment portfolio. You are essentially building a private legal system for your family's affairs. We must also address the handling of unforeseen economic shocks, such as inflation or a major market downturn. A robust settlement should include a provision for how the parties will adjust their financial obligations in the event of a significant change in the economic environment. For example, if the consumer price index rises by a specific percentage over a multi-year period, The support obligations are automatically adjusted to maintain the intended real value impact. This prevents the need for litigation just to keep up with the cost of living. It is a form of indexation that keeps the agreement relevant over time. Furthermore, we need to discuss the role of absolute disclosure requirements. In 2026, many agreements fail because they are based on a snapshot of financial data that is quickly outdated. A master-level settlement mandates an annual exchange of tax returns, bank statements, and business performance reports. This is a transparency clause that forces the parties to remain honest with one another. If one party refuses to comply with the disclosure, the agreement should outline clear, severe penalties, such as the forfeiture of a portion of the support payment or an automatic award of legal fees to the compliant party. This forces the parties to police each other, reducing the role of the court. Consider the concept of a sunset clause for support obligations. This is an explicit date or event after which all spousal support terminates. By setting a sunset date, you provide both parties with a clear horizon. The recipient knows that they must achieve economic self-sufficiency by a certain time, and the payer knows exactly when their financial liability will end. This creates a powerful psychological and financial incentive for both parties to plan for the future. It moves the relationship from one of permanent dependency to one of defined, temporary transition. We must also talk about the separation of business interests. In many high-asset divorces, the most complex issue is the buyout of the non-owning spouse's interest in a business. A master-level settlement does not just set a price. It sets a payment schedule that considers the business's liquidity. It might include a tiered payout system where the business owner pays a lower amount while reinvesting in the company, and a higher amount as the business reaches specific growth milestones. This aligns the interests of both parties. The non-owning spouse benefits from the business's success, and the business owner is not forced to starve the company of the capital it needs to survive. Building this kind of settlement requires a team of experts, tax lawyers, business valuation specialists, and financial planners who are focused on the long-term viability of the agreement. This is an investment. The upfront cost of building a master-level settlement is significant, but it is a fraction of the cost of the 20 years of litigation that often follows a poorly constructed agreement. You are buying your future freedom and your ongoing financial stability. This is the ultimate evolution of managing marital risk, moving from a reactive, litigation-based process to a proactive, contract-based process. You are utilizing the tools of corporate finance and legal architecture to manage the most personal risk of your life. When you reach this level of sophistication, you are no longer a victim of the court system. You are the architect of your own post-marriage reality. In the final part of this masterclass, we will synthesize everything we have discussed. We will look at the overarching philosophy of risk management in marriage. We will discuss why the ultimate protection is not a contract, a piece of insurance, or a trust structure, but the clarity and transparency of your own decision-making process. We will look at how to move forward with confidence, armed with the knowledge of the legal and financial structures of the American family in 2026. This is the conclusion of our deep dive, where we transform information into action. To reach this final stage of our masterclass is to acknowledge a fundamental truth about the American experience in 2026. Marriage is no longer merely a social or religious commitment. It is the most significant, high-stakes legal contract you will ever sign. We have spent this series dissecting the anatomy of marital risk, from the legal legacy of the no-fault transition to the forensic complexities of asset valuation, the rigidity of child support, the hidden traps of joint debt, and the relentless scrutiny of your digital footprint. We have navigated the landscape of what is fundamentally an unpriced liability. Now it is time to synthesize this knowledge into a coherent philosophy of risk management. The historical trends we have analyzed demonstrate a clear arc. The state has increasingly assumed the role of arbiter in the dissolution of domestic partnerships. The era of fault-based divorce provided a clear, albeit rigid, moral framework for the division of assets. The era of no-fault divorce, while promoting individual autonomy, simultaneously introduced a permanent state of volatility. Every marriage in the United States today is, by default, a contract that can be terminated unilaterally, with the state's standardized procedures dictating the division of your life's work. This is the reality. It is not an attack on the institution of marriage, but a sober recognition of its legal architecture. If there is one lesson to take away, it is that you cannot outsource your risk management to the state. When you leave your financial future to the default rules of family court, you are accepting a result optimized for administrative efficiency, not for your specific personal and professional goals. The role of what we have discussed as divorce insurance, or more accurately, the proactive hedging against marital dissolution, is not to prepare for the end of a marriage, but to ensure that the structural integrity of your financial life remains intact regardless of the outcome. Think back to our case studies. When individuals like Marcus or David approached their financial planning with the same rigor they applied to their businesses, utilizing trust structures, maintaining impeccable financial hygiene, conducting thorough audits of debt, and negotiating settlements with performance-based triggers, they drastically reduced their exposure to the worst-case outcomes of the legal process. They stopped being victims of the system and became participants in the design of their own financial reality. This is the shift from hope-based planning to data-driven contractual planning. We have seen that the most sophisticated protection is not found in a single product, because such a product effectively does not exist in the current market. Instead, protection is found in a multi-layered, multi-asset architecture. It is found in the separation of legal entities. It is found in the transparency of asset disclosure. It is found in the meticulous maintenance of personal financial boundaries. It is found in the realization that your digital footprint is an asset, or a liability, that requires active management. This is the work of a lifetime, not a one-time event. As we look toward the future of 2026 and beyond, we can anticipate that the law will continue to evolve. We are seeing more states experimenting with different approaches to alimony, more focus on the valuation of intangible assets like intellectual property and personal goodwill, and a growing emphasis on the use of technology to streamline the dissolution process. The risk profile of the American marriage is not static. It is constantly being reshaped by economic trends, technological advancements, and judicial precedents. Your strategy must be equally dynamic. You must remain an active manager of your own legal and financial portfolio. The most valuable takeaway from this masterclass is the necessity of radical transparency with your partner and with yourself. The financial devastation that often accompanies divorce is almost always rooted in a lack of clarity. It is born from a refusal to discuss the hard realities of money, debt, and expectation until it is too late. The paradox of marital risk is that the people who refuse to talk about the risks are the ones most likely to be destroyed by them. By engaging in the conversation, by establishing the boundaries, the contingency plans, and the structural protections, you are not preparing for failure. You are building a stronger, more resilient foundation for the partnership itself. Let us summarize the core tenets for moving forward. First, treat your assets as distinct from your marital union. Utilize legal vehicles that allow for the insulation of wealth. Second, maintain absolute, forensic-grade financial records. The person who has the better data wins the courtroom every single time. Third, view debt as a weapon that can be used against you. Audit your exposure, consolidate your liabilities, and secure your financial position. Fourth, recognize the power of digital data. Your footprint is permanent. Manage it with the same care you would manage your bank balance. Finally, always prioritize the construction of a resilient agreement over the hope of an easy resolution. The goal of this analysis was to move you from a state of blind, reactive optimism into a state of informed, proactive preparation. We have covered the history, the mechanics, the risks, and the defensive strategies. You now possess the framework to view the institution of marriage for what it truly is: a high-stakes, multi-decade contract that demands professional-level management. This deep dive into the abstract concept of marital risk is now complete, but your work in managing your own financial future is only just beginning. The complexities we have explored are not going to disappear, and the stakes of your financial life will only continue to rise. As you go forward, maintain this analytical perspective. Do not fear the risk, but do not ignore it either. Master the structure of the system, and you will find that you can navigate even the most challenging circumstances with the precision and confidence that informed preparation provides. You have the tools, the data, and the framework. The rest is now in your hands. Thank you for joining us for this masterclass on the financial architecture of the modern American life.